After for the people. Pockets.
What's these people on? Why is he repeating what I say?
Aspirations.
Oh, wow. Okay.
This is Public Defender Jay Bones on behalf of Mr. Hawkins, who appears to my right. Your Honor, Mr. Hawkins, can you please state your name for the record?
Aaron Hawkins.
Thank you, sir.
All right.
Your Honor, it's my understanding that we're to be asking for a 3-week adjournment on this matter so that we can continue a referral for drug treatment court. Is that what you're being referred to? This is this Pater case. She's not here today. I understand that there's a bond violation in this matter as well. We have discussed that, Your Honor. My client is willing to admit to the violation, Your Honor. He would be asking for a scram tether. He's asking so that he can continue working. He works for a trucking company. He is not a driver for a trucking company, however, but he would like to maintain his employment. He advises that if he is ended today, that he's going to lose his job. He's hopeful for a scram tether so that we can keep track of him that way in terms of any future allegations, which he submits that he won't have any.
I don't know if there's anything from the people.
And what was the nature of the bond?
On October 26, 2024, at 12 a.m., he blew a .055, then continued to blow numbers throughout the morning through the 26th and admitted to consuming alcohol.
Your Honor, I would just let the court know, and this might be in the bond information. One of his priors is a high BAC.
Yes.
19. This present case, the alcohol level was a 0.17.
Yeah, that is, Your Honor. We would respond briefly by stating that that is why he's trying to get into the sobriety court. He recognizes that he has an issue and he's asking for leniency and getting a scram tether so that he can be better monitored. He did ask for that at arraignment. He wasn't given that, however, but recognizes that there is an issue.
What are you asking me to do with the case?
Adjourn the matter for 3 weeks so we can continue the referral.
Tell you what, I'm going to adjourn it out 1 week to, but at this time, until he's got something in place. He isn't even going to have anything in place, does it?
He does have the
what?
The portable, Your Honor.
Yeah, that didn't do any good.
I understood.
I mean, I'm talking in terms of any treatment, anything. What's he doing in terms of any treatment?
I'm sorry?
What's he doing in terms of trying to get himself into treatment?
Can I speak? That's what I was waiting for. I was waiting for the attorney to let me know what I was supposed to do next. That's
in terms of the referral for drug treatment court, Your Honor, with Judge Conkey.
Right, but you can get yourself into treatment.
Have you done anything?
You're now here on your second drunk driving. First one was, from my understanding, a high BAC.
Right.
You don't even make it through a couple of weeks in terms of a bond condition of being on the sober link before you're blowing numbers, and you're not blowing them at a low rate. If you didn't have an attorney, you still have a problem and you need to deal with that. So don't try to blame somebody else that I'm waiting on something. This time defendant's bond is revoked, defendant's remanded.
Thank you.
Assistant Public Defender Mike Geddes, on behalf of Mr. McKinney Hollowell, who's making his way to the podium, Judge. Oh, we already resolved. No, we resolved the case.
It was his baby making all that noise.
Yes, sir.
The resolution in this matter, the defendant will be pleading to an added count 4 of illegal entry with an agreement to probation with participation in therapy. In exchange, counts 1 through 3 would be dismissed. Additionally, the victim is present and would like to address the no contest order.
I believe there's also a sentencing agreement in no affront jail.
That is correct.
All right, and understanding that I can take the plea, I can't bind the sentencing judge to that.
Well, to the sentencing, sentencing agreements between us, but yes, Judge.
Yeah, I
We will
know,
not
but
object.
Thank you, Judge.
to the extent that you think I'm binding the court, I am not.
Thank you, Judge. I have gone over the advice of rights with Mr. McKinney Hollowell and signed a sentencing judge waiver. There's no Padilla issues, not on probation or parole.
Does he, and he has signed the advice, right? Good enough. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Latrell McKinney Hollowell.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of illegal entry without owner's permission. Is that correct?
Yes, sir.
That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, sir.
All right. You understand what a no contest plea is?
Basically, like, I guilty, but
You're not admitting.
you're not admitting guilt. Like, is that what it is? sir?
I've explained, yes, Judge, I've explained that it's the same conviction as a guilty plea, but he's not admitting guilt on the record. Purpose for the no contest plea today would be, or the reason would be civil liability.
So, two things about a no contest plea I need you to understand. I have reviewed and would review a police report, take those facts as true in terms of determining whether or not a crime was committed. You understand that?
Yes, sir.
Has been provided and has reviewed Ann Arbor Police Department report for their case number 24-33126. Any objection to the court having reviewed that report?
Yes, Judge. No, the defense is satisfied, Judge. No objection to you reviewing the report.
Eventually, you're going to hit it, right? All right. Based upon a review of that report, the court does.
On my chest.
The court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Now, has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's no contest plea to count 4 counts, 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
September 27th at 10 a.m. with Judge Perry.
September 27th, 2024. What time?
10 a.m.
10 a.m. before Judge Perry.
Your Honor, is that the DB docket?
I have no idea. These times go all over the place. I start at 9.
No, I'm sorry, it is not the DB docket. The correct date then would be September 18th at 10 a.m.
September 18th, 2024 at 10 a.m. Same time.
Your Honor, I believe I mentioned this earlier, maybe I did.
You didn't bring it up.
So the victim's present would like to address.
Come on. All right. Move to the side.
I had asked if the no contact order could be dropped.
Well, you don't have to yell at me. Come on up to the podium. I mean, if you want to scream from back there, you can. Hello, what's your name?
My name's Eulacia.
Okay, and what would you like to tell me?
I was asking the prosecutor and the defense attorney if it was okay if the no contact order be dropped.
Okay, why?
I didn't feel like Latrell was a threat to me, the community, or the kids. Actually, he's probably one of the safest people I could trust with my kids. And, you know, the community seems to have a liking to him. So I didn't think that it was that serious where they just blocked all contact. And then also we have a 7-month-old. So it's, you know, kind of busy with him right now. He's in the teething walking stage. And I know how they're
That's
bonded.
not the one back there.
Yeah, Mr. Fussy. Yeah.
That was the one making all that noise?
Yeah. the
That's
7-month-old.
your guys' baby? Okay, I don't mind the noise. I'm just glad that baby looks like his mother and not him.
Oh my God.
Just saying. Just thought I'd throw that out there. Just, look, I'm just honest.
Oh,
Got a chance.
and also I have the paperwork. Mom just bought the birth certificate, so we have to actually go turn the birth certificate in so he could be added onto the lease because they're switching our units. So my property manager, she's already like aware of what's going on. It's
Okay,
just that
hold
since I
on,
can't
hold on.
contact-
You like switch gears and went someplace else.
It's since I can't contact him, I can't.
Oh,
get it
so
done.
this has to do with the no contact.
Yeah.
So
and
you just want me to lift the no contact
please and
so
thank you.
that,
That we can get this is important though, because it's kind of like a lease thing going on right now.
were you talking to this Yagi?
Oh.
Never mind. Never mind. Just think. Do the people have any position or are they fine with switch? All right.
And we'd ask that the tether be removed from Mr. Kenny Howell as well. The court's gonna grant the contact.
Well, congratulations on the little one. I'm gonna let the no contact provision is lifted. All right. I will also, we will delete the tether provision. He's on a GPS.
Yes, Judge.
Bond will continue in all other aspects. You understand that, young man? You wasn't listening. You just wasn't listening. Should just put it back in. I'm not gonna do that to you. You're the only reason I'm gonna let him go. All right. You're welcome, man.
So Your Honor, I can go home now, is what you're saying? I'm good to go home.
Is that where he came from? Were you home before?
That, I wasn't really do not contact, I wasn't allowed to go to the house.
Oh, ma'am, I am so sorry you had to deal with that. Okay. All right. Yes, you can go home. All right. Take care, ma'am. Bless you. And that baby.
Your Honor, may I please address bond?
Sure.
Thank you. Currently, my client's bond, I believe, is set at $10,000 cash as surety. She is 35, the mother of a 7-year-old who is currently residing with her father, who is 75 and has some difficulty caring for him. So she's asking the court to consider a personal recognizance bond with home confinement. And as the court is aware, because of the age of this case, there was a prior failure to appear. There was some.
Where was she?
I'm not sure if I even received that.
She doesn't remember, Your Honor, what happened, but she will be appearing.
It was like years.
Huh?
Years she was gone.
I understand, Judge. And then as an officer of the court, I have also been informed by the prosecutor's office that there is possibly a pending retail fraud and a felonious assault matter. My client is unaware of what the felonious assault allegations may be, but she is aware of the retail fraud matter. So, and as the court is aware, this is a possession case. So we ask the court to please consider a personal recognizance bond with home confinement.
Today is the Yagi School of Bond Argument. I don't need a response to the people. Motion for bond reduction denied.
Very well.
Thank you.
Thank you.
Sign that information.
Yes, sir. I think it was. I think. Was it? Oh, yes. It's right. Still on the bond argument. What? It's recall.
Hear it again, Judge?
Hear what again? Your bond argument? That's funny. She doesn't show up for like months on end, and now she comes in, just got all kind of jokes. All right.